In this episode, I would like to discuss about what is the distinction between tort and crime. By nature, there is similarity between the tort and crime because in each case, a person is injured or is suffering because of the conduct of any person. A person has caused some injury upon another person, that may be a kind of tort or crime. Now, what is the similarity between tort and crime and what is the difference between tort and crime? This is the topic of discussion today. The word tort originated from the Latin word tortum. In English it means to twist. So, tort means what is not straight or which is twisted or crooked or something which is wrong or unlawful. So, what is the etymological meaning of tort? We have to consider the various definitions given by the eminent persons. Salmon stated that tort is a civil wrong, the remedy of which is common law action for unliquidated damages and which is not exclusively the breach of contract or breach of trust or other merely equitable obligation. Winfield stated that tortious liability arises from the breach of a duty primarily fixed by law, and that duty is towards the persons in general and the breach of which is redressable by action of unliquidated damages. According to Fraser, the tort is infringement of a right in rem of a private individual and which gives the right of compensation by filing the suit by the injured party. And according to section 2 clause M of the Limitation Act 1963, tort is a breach of a duty which is not exclusively the breach of contract or breach of trust. So, it transpires from the various definitions of the eminent persons that tort is connected with the civil wrong and the remedy of which is common law action for unliquidated damages. So, that means here the compensation is awarded and moreover the term is used that civil wrong, so not a crime. So, it indicates that there is the distinction between the tort and crime. So, tort is always connected with the commission of civil wrong and the remedy is a mere compensation, but no corporal punishment is awarded like in case of commission of any offense. Now, let us discuss what is the definition of the crime. So, crime is that any act or omission for which the punishment is prescribed. If there is crime, certainly there will be punishment as a remedy, like corporal punishment, that is rigorous imprisonment is prescribed. So, that is the main difference between tort and crime, that in case of tort it is considered as a civil wrong, that means it is not too much grave in nature, whereas in case of crime it is considered always a much grave in nature and for which the compensation is not awarded by way of any money. That means monetary compensation is not awarded in case of crime, which is awarded in case of tort. In case of crime, the remedy is corporal punishment or simple imprisonment as the case may be. So, that is the main difference between the ingredients of the crime and the tort. The tort is connected with the civil wrong and crime is connected with the commission of some offense. It may be by way of any commission or it may be by way of any omission. And in case of tort, the remedy is the compensation, monetary compensation, whereas in case of the crime, the remedy is the corporal punishment. Now, let us consider the various aspects of the difference between the torts and crime. Now, first is as to the nature, difference as to the nature between the torts and crime. So, in case of tort, a particular individual is affected. The injury is caused by one person upon a particular individual, whereas in case of crime the entire community is affected. So, in case of tort only the individual is affected, but in case of crime the community as a whole, that means society as a whole is affected. So, this is the difference between law of torts, means a kind of torts, and crime. And next point is, that is the procedure, means procedure of taking the action. In case the tort is committed, the step is to be taken for relief by the affected individual, that means the person who is injured, he is to take the action, he is to initiate the proceedings against the wrongdoer, whereas in case of crime the steps will be taken by the state, that means in the name of sovereign the action will be taken. There will be the lodging of general diary, then it may convert it to FIR, and then code of criminal procedure will be followed. So, this is the procedural difference between the torts and the crime. And next is in case of remedy. In case of law of torts, means in case of the tort, if the wrong of tort is committed, then the remedy is generally by way of compensation awarded by the court, and which is also unliquidated damages, that means it is not determined earlier. It depends upon the factual matrix of the case, that means as per the facts and circumstances of the case, whereas the remedy is available in case of crime, that is the basically corporal punishment or physical sentence, that means the rigorous imprisonment is generally awarded by the criminal courts in case of the commission of the crime. And next point of distinction is as per the gravity. In comparison with the crime, the tort is less grave, that means crime is much more grave in nature. So, crime has a much more baneful effect on the society. So, that is why it is treated a little bit stringent manner. So, that is why corporal punishment is prescribed, whereas in case of the tort, in comparison with the crime, it is less grave in nature, that is why here the adequate remedy is by way of compensation. So, let us have a look that as per the nature of wrong, tort only individual is affected, crime community is affected, and procedure in case of tort action can be taken by the injured person, whereas in case of crime action can be taken by the sovereign, that is state. In case of remedy, in case of tort compensation is awarded, and in case of crime punishment like imprisonment is provided. And in case of fourth point, that is gravity, in tort is not much grave in nature, whereas crime is much grave in nature. So, these 4 points are the principal difference between concept of tort and crime. Now, I would like to discuss various wrongs which are punishable both in law of torts as well as in law of crime. And in this aspect, I would like to discuss about the concept of Indian Penal Code, which provides various types of the offences and prescribe their punishment. So, let us have a look that first is nuisance. We know that nuisance is a wrong, a kind of tort under the law of torts. Similarly, nuisance is a kind of offence prescribed by our Indian Penal Code 1860. Now, various sections are there relating to the provisions of nuisance. Now, section 268 defines the public nuisance, that whoever makes any obstruction, annoyance or danger to the public, that means because of his act public life is being endangered, or there is any something creation of annoyance or disturbance to the public. So, that is coming within the purview of section 268. And 269 also says that whoever negligently spreads any disease or any infection so that public can suffer. So, because of his negligent act, that any disease is being spread so that public may suffer at large. So, this is punishable. 279 prescribe the provisions of the rash driving. So, rash driving is also punishable. So, these are coming under the purview of penal code. And second, we know that negligence is also a wrong considered by the law of torts. And similarly, in case of Indian Penal Code, section 284 deals with one aspect of negligence, that is negligent conduct with the poisonous substance, that if any person negligently handles any poisonous substance actually which may endanger the life of the human being or which may cause any hurt to the human being. So, that is also an offence in the light of Indian Penal Code. And as well as section 289 says that negligent conduct with any animal. So, that if any person keeps any animal and he cannot control it, and where there is the probability that there may be the human life may be in danger because of that uncontrolled animal. So, he will be responsible for that. There are some other sections, now I am discussing one by one. Now, next point is, that is battery. In case of law of torts, a particular wrong named as battery, and that is similar like the concept of hurt or grievous hurt discussed in the Indian Penal Code. Now, what is battery? Battery means, in pursuance of law of torts, that when a person is applying the physical force upon any person, that means he has either slapped him or kicked him or pushed him, that is the kind of battery. That means there is the use of actual force by a person upon another. So, when a person is kicking or boxing or something, means slapping a person, another person, so that is the kind of battery, that is use of actual force. But this term is not used in the Indian Penal Code, whereas in Indian Penal Code the term is used there as hurt or grievous hurt, like section 319 of the Indian Penal Code, as I have written, it has defined the concept of hurt, that means whoever causes bodily pain or infirmity or disease to another person is said to cause hurt. And 320 defines the grievous hurt. The following kinds of hurt are considered as grievous hurt, like emasculation, permanent privation of either sight of eye, permanent privation of either hearing of ear, dislocation of the tooth, or dislocation of any member or person body parts. So, these are kind of the grievous hurt and which are punishable, like section 323 of the Indian Penal Code punishes the hurt, that is may extend up to 1 year, and 326 it is the punishment in case of grievous hurt caused by some deadly weapon. If the attempt is made of causing the grievous hurt with some deadly weapon, then that may extend up to the imprisonment of life or a minimum 10 years rigorous imprisonment. So, these are the punishment prescribed by the Indian Penal Code. Term is different. So, where it is used as battery, there it is used as hurt and grievous hurt. Next item is false imprisonment as used in law of torts, and whereas in case of Indian Penal Code, that is wrongful restraint and wrongful confinement. So, let us have to discuss what is the concept of false imprisonment prescribed in the law of torts. False imprisonment means the total restraint of a person, whatever may be the short duration of time, without any lawful justification. So, if any person restrains another person, maybe it is for a short period of time, but without any lawful justification, that is called the false imprisonment. And the same concept is used in the Indian Penal Code, termed as wrongful restraint and confinement. Now, Blackstone stated that every confinement can be considered as false imprisonment, whether it is in common prison or in the private house or in stocks. If the person cannot move, that means even the restraint in the public street by a person to another, that may come under the purview of the false imprisonment. And then means wrongful restraint, as it is defined in the Indian Penal Code, it is stated that whoever causes any obstruction to another person so that he cannot move in a way where he has a right to move. So, he is being restrained by one person to proceed in a particular direction where he has a right or liberty to move, that is called wrongful restraint. Section 339 defines and 341 prescribes the punishment that whoever commits the wrongful restraint will be punished which may extend up to one month imprisonment. And wrongful confinement means restrain a person in such a manner so that he cannot go beyond a circumscribing limit. So, particular circumscribing limit he cannot go beyond, that is the wrongful confinement, and whoever commits the wrongful confinement punishable under section 342, defined under section 340 and punishable under section 342. So, it is similar with the concept of the false imprisonment. So, wrongful restraint and wrongful confinement are alike the concept of false imprisonment of law of torts. Next kind of wrong which I would like to discuss, that is defamation, which is a wrong both in law of torts as well as in Indian Penal Code. Now, in law of torts, the defamation is divided into two parts, one is slander, another is libel, whereas in Indian Penal Code it is named as defamation. Now, slander means if any person by mere word of mouth makes some imputation relating to some other persons whereby his reputation can be endangered. So, that means that is a defamatory statement. So, that is called slander. And libel means which is a little bit permanent in nature, like a kind of painting or writing. So, if any person published something in writing or by painting some defamatory statement against any person, that is called a defamation under the law of torts. Whereas, in case of Indian Penal Code, it is defined under section 499 and punishable under section 500. It is also a kind of statement and which consists with some imputation of some reputation by which the reputation of any person can be endangered. So, this is the concept of defamation prescribed by law of torts as well as in Indian Penal Code. In Indian Penal Code, it is defined under section 499 and punishable under section 500, which may extend up to imprisonment of 2 years. So, defamation is a kind of wrong as well as offence both under the law of torts as well as in Indian Penal Code. So, by this way I have given some examples of wrong which are both punishable under the law of torts as well as Indian Penal Code. So, this is the actually similarity between the law of torts and the law of crime, as well as the differences. Similarity is there because these all are considered as a kind of wrong under both the law, but there is the difference, and I have discussed both the similarity and difference as well.